Actually, I need to update that because I have a partner now, so it's Battaglia and Walteri. And I'm sitting down because I had knee surgery, and although I'm doing pretty well, standing up for an hour isn't going to be good for the knees just yet. So thank you for coming. Everybody hear me okay?
Yes.
Really? Is it too loud?
Yeah.
Okay.
Can I turn it down? It's too loud, right?
Too loud? I think it's okay.
Okay. So tonight we're going to talk about planning ahead for a child with mental illness. I think all parents, no matter how old their children are, have some concern about what will happen to their children when they're not around anymore. I have a 27-year-old daughter and a 25-year-old son, and I'm sure that they could not get along without me, even though they don't live with me anymore. So you're always concerned about your children, but especially if they have mental illness, I think that, from my experience, many parents are very worried about who's going to fulfill that role in their child's life when they're no longer around. Because the parents have struggled with the mental illness for maybe many years of that child's life. They have some idea of what works, what doesn't work, what to do when episodes might occur. And that knowledge about that child is something that they're very worried about trying to replace when they aren't there anymore. So there's many, many things that parents of a child with mental illness are thinking about. Just to name a few, I get questions about conservatorships, powers of attorney, financial needs for a child, how much money am I going to need to put away in order to make sure that my child will have enough to live on, aging caregivers, parents that are getting older, estate planning for the parents, do we need to do a special needs trust? In addition, other worries are that some of the services that have been available are now getting cut because there are cuts in both federal and state funding for many of these programs. So I'm not going to cover all of these things in depth. It's going to be kind of a broad brush, but a little bit of an introduction to each of these things. So one of the major questions that parents come to me with is who steps in when parents are gone and there aren't any other caregivers. Sometimes there are agencies to serve the mentally ill. Sometimes there are friends and family members. But there's also another category, especially in California, there are professional fiduciaries who will be a good choice for circumstances where maybe there is no family. And I will talk about them again later on in the presentation. I'll give you a website that you can go to learn more about professional fiduciaries. But they are a good substitute, sort of like building a substitute family for somebody who doesn't necessarily have anybody that either wants to or can step up to the plate and fulfill that role that the parents have been filling. So when you think about planning ahead for your mentally ill child, it's a good idea to sit down and write down what your objectives are. These are just some examples of objectives that people come in to be with, because those objectives then are going to sort of be an outline of what you would be talking about with your attorney, and making sure that when you get to the end and you get all these documents signed, that you have at least addressed or accomplished most of your goals. Oftentimes, preserving government eligibility is a primary goal because the Medi-Cal healthcare funding that they get through public benefits may be absolutely essential. Also, identifying other people, agents or caregivers that are going to be able to step in for the parents and then educating advocates to carry on in your absence. So one of the things that we do with our practice is we give our families a memo of intent, either in a Word document or WordPerfect, depending on what you use in your computer. And that memo of intent is kind of your letter to future caregivers about things that they might need to know about your child in dealing with them, things that you'd like to tell somebody about how you want the money used. It's a personal type of letter that is for the future caregivers, not something that you want to put in a legal document that's going to be circulated to financial institutions. We do it in like a Word document so that you can save it on your computer and update it. I mean, if the child's birthday or New Year is a good time to look at that and say, what do I need to add? What do I need to change? But it's always available to easily update once you fill out the major part of it. So in thinking about your child with mental illness, one of the first things that you need to sort of address is whether or not your family member is fully independent. And that's hard to say in many circumstances. Sometimes they might be, sometimes not as much. But if they are not able to really be independent, then you really need to think about some special planning for that child. Do they have capacity? That's a very tough question for somebody with mental illness. Sometimes, some days they might have capacity and some days they might not. What about their legal or decision-making capacity? Just because they make bad decisions, though, doesn't mean that they don't have capacity. Everybody's got the right to make bad decisions or bad choices. There's also an issue of what are the legal rights versus the mom and dad rights. If you have been dealing with medical issues with your child for many, many years, the doctors, the therapists probably will talk to you, give you information about your child without worrying whether or not you have the proper documentation once they become 18 and they're an adult. But if you go to a new doctor or there's an emergency, somebody may question whether or not you have the authority, even though you're the caregiver, they live with you, whether or not you have the right to get that information. Because once somebody turns 18, if they're not conserved under a conservatorship, they're considered to have legal capacity. Conservatorships in California are for individuals who are 18 and older. If they're under 18 and maybe the parents are not able, they're deceased or not able to care for them for other reasons, then there's a guardianship. A grandparent might get a guardianship for a minor child. But in other states, they call them all guardianships. So, if you go to another state and it's an adult, it may be a guardianship rather than an alternative. Now, advanced healthcare directives and also powers of attorney can be alternatives to doing a conservatorship, which is a legal proceeding in the court. If you think that your child has capacity and they can decide who's going to help them, there are some documents that can be executed around the time that they turn 18, soon thereafter, that will give other people the power to act on their behalf. There's educational powers of attorney, because many times students with disabilities will stay in school past the age of 18 and up to age 22. There are financial powers of attorney, and there are healthcare proxies that in California we call advanced healthcare directives. But if a child has capacity to name these individuals to act for them, they also have the power to fire those individuals when they're making decisions that the child doesn't like. So this can be a good alternative, but if somebody is going to be fickle about whether or not they're going to allow you to use this power of attorney, it may be a fairly worthless document because somebody can say, well, yes, I signed that, but now I revoke it, and it's revoked. So conservatorships. If you do have questions, can you just scribble a little note, and then when we're finished, I will take all the questions. So what is a conservator? Something that is done by the court, and you're appointed by the court to make decisions for somebody who's determined to be unable to make decisions for themselves. That's a little bit broad, but within the conservatorship category, there are two kinds of conservators. One is a limited conservator, and one is a general conservator. A limited conservator is, a limited conservatorship is for a child who is usually developmentally disabled. Maybe somebody who has autism, Asperger's, Down syndrome, various kinds of disabilities like that. I usually ask my families if that child is a client of Regional Center. Regional Center is a statewide organization that serves the developmentally disabled. If that person is a client of Regional Center, then it's going to be a limited conservatorship. A general conservatorship is for everybody else. It's for the adult child who's not developmentally disabled. It's for elderly parents when they're not able to handle their own affairs. A limited conservatorship has 7 powers that you can potentially ask for when you go to court for the conservatorship. The effect of being awarded all of the 7 powers is really the same as a general conservatorship. You have the same powers. It's just different language. But the thinking is that if somebody's developmentally disabled, the court only wants to take away or give to the conservator those rights that are absolutely necessary. A general conservator will be able to do all of those things too. Decide on the residence, have access to confidential records. Actually, you have to ask for special powers to withhold consent for marriage. You can control their right to sign contracts and to give medical consent. So those are all pretty general if you're going for a general conservatorship. Within each of these, limited and general, you can have a conservator of the person and a conservator of the estate. Conservator of the person would, if it's a limited, would have the ability to do all of those 7 things. Pretty much the same thing if it's just a conservatorship of the person for a general. Once if you only could petition for conservatorship of the person, once you get that award by the court, you don't really have to go back to court on a regular basis. That's an ongoing or permanent appointment. There are court investigators that will come out about every other year to visit the conservatee, and if circumstances are pretty much the same, then there's nothing more that happens other than a report is generated. On the other hand, if they find that the person who's conserved is not eating properly, not being taken care of, then they will suggest, then they'll tell the court that a hearing needs to be scheduled about why this conservatee isn't being taken care of. I've never had that happen with any of my conservatorships. They're parents and they're very concerned about their children. So for the most part, we never go back to court once you get that. But if your child does have money and you need to have control of that money, that's a conservatorship of the estate. You probably want to avoid that unless it's a fair amount of money, because you're going to have to account to the court on an annual basis. Sometimes they'll let you go every 2 years for every penny of that money, and the accountings are very strict about the format and the information that needs to be given to the court. An attorney needs to write a petition that goes along with the accounting of all the numbers. So you have to pay a filing fee, you have to pay attorney's fees, and if it's, a small amount of money, like, $25,000, the fees are going to eat up that money. So sometimes I will tell my families, this happens like if grandma or grandpa set up a Uniform Gift to Minors Act account, and then they're going to turn 18, you can use that money, you can spend that money for the benefit of that child. You can't just take the money and put it in your own account, but you can use it for the benefit of that child, and that might be a better use for it than waiting until they turn 18 and then having to put it into a conservatorship. It depends on how much money we're talking about. So, one more thing I wanted to tell you about the conservatorship is when you do petition for a limited conservatorship, the court appoints an attorney to represent that person. So if your child doesn't want a conservatorship, that court-appointed attorney has to object to that conservatorship. You probably don't want to go that route if your child is really going to object, because it's going to be an expensive trial about whether or not you should be appointed. But they do get a court-appointed attorney under a limited. In a general, right now, a court investigator does a report, but at the time that the court investigator talks to the child, the proposed conservatee, they will ask that person if they want to be represented by an attorney. And if that person says yes, then they will again get a court-appointed attorney. So if there isn't harmony on this particular topic, you might want to not go down that road. So is conservatorship necessary? With a child with mental illness, that sometimes is one of the most difficult decisions. If they're high functioning, it may be a real blow to their ego to have a conservatorship, and so that's a consideration. How much property is at issue? Whether or not they rely sufficiently on friends and family to help them in times of need, and again, how they would react if they did have somebody appointed by the court. I've had many circumstances, though, where adult children with mental illness know that they need their parents' help. They've relied on their parents. They're very close, and they want those parents to have legal ability to help them, even in times when they're having episodes where they might have to be hospitalized. So an adult child can petition themselves and can ask for a conservator. If that happens, there's no court-appointed attorney, there's no court investigation, because that's an individual who's asking the court themselves, please appoint my parents as my conservators. So they are the petitioner, or the person that's going into court to ask for this to happen. About the time that you are considering conservatorship for an adult child, which is about, if you have a child that's turning 18, you can start the conservatorship about 6 months in advance, and it becomes valid. The order becomes valid on the 18th birthday. You can do it any time after that. We'll do it for somebody who's in their 20s or 30s. Because sometimes parents don't see a need for it until they get older. But at the same time that they're turning 18, another event often happens, and that is that child becomes eligible for certain government benefits. So not only are parents interested in the conservatorship, but they're interested in applying for Social Security benefits that their child will be eligible for. And there are a couple of different kinds of government benefits. Some are insurance type benefits. Others are means or needs-based. Social Security has two kinds of benefits: Social Security disability and supplemental security income. And then there's Medicare and Medi-Cal. And then there are other benefits too, like in-home support services. So it's hard to keep all of these things straight. Even if the family might be wealthy enough to say, money is not an issue, we can support this child for the rest of his or her life, we have plenty of money, there still is often a motivation to keep that qualification for public benefits for a couple of reasons. If they're a client of Regional Center, many of Regional Center's programs are set up to run for people who are eligible for Medi-Cal. If they're not eligible for Medi-Cal, they're not sure what to do with them. They can't fit them into the program, and they just don't plug it in. So in order to kind of keep the public benefits organized for you and straight in your mind, I have this chart. So on the left-hand side are entitlement benefits. Those benefits people get because they work, they did something with their work history where they're entitled to get these benefits. Doesn't matter how much money they have, how much income they have. Bill Gates can get Social Security disability if he becomes disabled and he can't get a paycheck anymore. Probably doesn't need a paycheck. But also under Social Security are adult children who became disabled before the age of 22. So if mental illness manifested itself before the age of 22 and a child is sufficiently debilitated by the mental illness that they're not able to hold down a job, when a parent begins to take Social Security or passes away, that child is also entitled to Social Security. It's one of the most overlooked government benefits. The child receiving regular Social Security doesn't reduce the parent's benefit. The child will get about half of what the parent gets when they retire. So if the parent's getting $2,000 a month of regular Social Security retirement, your disabled child will get $1,000. So, once the parent is eligible, if you're retiring and you have a disabled child that was disabled before the age of 22, you need to tell Social Security about that. Because mental illness often doesn't manifest itself until late adolescence or early adulthood, you have to have the documentation. So that first-time diagnosis is important to keep in your records so that you'll be able to prove this to Social Security if you're trying to access this benefit. Once somebody gets Social Security for 2 years on disability, not retirement, on disability, then they get Medicare. So a child who's maybe 21 and starts getting Social Security disability under a parent's Social Security number will also get Medicare. And the other side are needs-based benefits, and those are for people who have very little in terms of income and resources. They're very limited, and they're not able, and they're disabled. They're not able to work, or they're only able to work a little bit. So supplemental security income, SSI, is for people who are aged, blind, or disabled. They have little or no income. They can only have cash assets of $2,000 or less. And the SSI payment is supposed to pay for food and shelter. The most you can get right now under SSI is about $850 a month unless they're in important care. That's not enough for somebody to survive, but as long as you get $1 of SSI, you automatically get Medi-Cal. And Medi-Cal can be a very important component because that's the healthcare coverage. Sometimes there's no other healthcare coverage. They can't qualify, they're denied by many health plans, and so that's the only healthcare coverage. So all they have to do is qualify for $1 of SSI, and then they get Medi-Cal automatically. You can qualify for Medicaid alone, but the easiest way to do it is to qualify for SSI. So I have many families that have children that get both. They get some SSDI and some SSI, and they get Medicare and Medi-Cal. When somebody says they're Medi-Medi, that means they get Medicare and Medi-Cal. And that's really kind of the best of both worlds because more doctors will take Medicare than Medi-Cal. Your health care coverage will be covered between the two of them. The only issue will be if you have doctors who don't take either one. You may still, if you can, have a supplemental policy, that would help. Also under needs-based, you can qualify for Medicaid on your own. It's called Medi-Cal in California. It has different names in other states. Sometimes it's Medicaid, sometimes they have completely different names. Also needs-based are in-home support services. If an individual requires the assistance of a caregiver on a regular basis, you can get paid by in-home support care if they also qualify for Medi-Cal. And Section 8 housing is cheaper housing. You actually can live on the $850 a month if you are in Section 8 housing. People who get Section 8 housing and really treasure that benefit, it's probably one of the most important. If you have a child who gets any of those needs-based benefits, and when you're doing the estate planning, you really need to take any correspondence or the most recent correspondence from Social Security to the attorney so they can see for sure what kind of benefits the child gets. If you have a child that gets any of the needs-based benefits, then you really have to think about doing some special planning. Because if you pass away and you leave them money, that's going to be over the $2,000 and they're going to lose their benefits. So there are ways to preserve that. Okay, basic estate planning is usually who gets my stuff, when and how do they get it, who's going to take care of my minor or disabled children, and who makes sure that all this is carried out. And those are the basic things that people want done in an estate plan. A well-drafted estate plan will cover those things. The old way to take care of somebody who was on SSI getting public benefits was to disinherit them. And that's not a good way to take care of the problem. Disinheriting somebody and saying, well, I'll leave it all to the rest of my kids. They'll take care of Mary. If she needs anything, they'll take care of it. Your other children might be dependable, but you don't know that they're going to survive the life of the disabled child, and their spouse, who would then inherit their share, may not be so inclined to use that money for the disabled child. Their children may not be so inclined. So if you really want to ensure that there are funds available for a disabled child, you need to think about a special needs trust. Most people in California need a trust if you own real property or you have assets that are over $150,000, because our probate is expensive and it can take a long time, and trusts will avoid that. If you have minor children or you have disabled children, then a trust is also going to serve the the purpose of setting up who's going to take care of your property for your minor children or for your disabled child. When you do a trust, there are 3 hats, and you have to think about which hat you're wearing at different times. So there's always 3 hats. There's the person who makes the trust. Sometimes they're called the settlor, sometimes they're called the trustor, sometimes they're called the creator. But the person who makes the trust, I usually use settlor. The person who administers the trust, it could be plural, the people who administer the trust, they could be co-trustees, or they're the trustees. They're the ones that are going to take care of the property, pay the bills, invest the money. And then there's the person that gets the benefit of the trust, the beneficiary. When parents first set up like a revocable living trust, they have all 3 hats. They're the settlor, they're the trustee, they're the beneficiary. I mean, the children may also benefit, but the parents are the immediate beneficiaries of their own trusts. You'll always be the creator, but you will not always be the trustee or the beneficiary, because you name successor trustees when you're doing your estate plan. And who you name as a successor trustee is one of the most important decisions that you'll make in your estate planning, because that's the person that has to carry out your wishes. So, you need to think long and hard. You need to ask that person if they're willing to serve. You should never choose somebody who has any financial difficulties, because you're putting them in charge of money for somebody else. If they realize nobody's going to know if I just borrow this extra $10,000, I'm going to put it back. So you have to build in a system of checks and balances in your trust to make sure that somebody else is always looking over the shoulder of the trustee. You must require that they account to the beneficiaries as to what they're doing with the money. So the trustee is you when you set it up, but you pick a successor trustee. The beneficiary is you when you set it up, but eventually the beneficiary is going to be probably your children, maybe some other relatives. Trusts can be created in several different ways. They can be created as part of a will. That's common in many other states because their probate process is much easier, not so expensive. They can be revocable or irrevocable. Revocable means you can say, I don't want this trust anymore. You can amend it many times as you want. And you can also set it up to pay out for your children in whatever way you think is going to work best. Maybe you think, one of your children isn't so good with money. You want to make sure that there's always some money to take care of them. So you might have their share in trust until they're 50 years old. Maybe they get, a little lump sum distribution all along. But another child is very responsible and they can have their inheritance outright. Those are all things that you can do within your trust to personalize it to your family. Now, if you need to do a trust for a disabled beneficiary, and usually you're usually trying to preserve an eligibility for needs-based assistance. There's no requirement that somebody actually be getting needs-based assistance. You just want to keep that eligibility or the potential to qualify available. Special needs trusts are usually the way that somebody makes arrangements for a disabled family member, and there are 2 kinds of special needs trusts. One kind is called a payback trust. It's also called a first-party trust. The other kind is called a third-party trust. Third-party are also called supplemental benefits trusts. They both have the same goals, which is this is extra money that's going to enhance the quality of life for that beneficiary in case they are having to try to live on that $850 a month, the special needs trust is going to pay for all of those extras, a car, a television, cable, monthly cable, computers, all those other extras in life that you want to be able to provide for that child. So the main difference between the two kinds of special needs trusts, and I'm telling you this because I know that people are going to talk about special needs trusts, and I want you to understand which kind is which. Third-party special needs trusts are funded with money that comes from somebody other than the beneficiary, usually parents, sometimes grandparents, sometimes I've even had a neighbor create a third-party special needs trust. This is the estate planning kind, and probably the most common kind. It's funded with assets that belong to somebody other than the beneficiary or their spouse. There's no payback requirement, and I'm going to tell you what that means when I talk about the other kind. But there's no payback requirement, they're simpler to administer, and they have more flexibility. So setting up a third-party special needs trust for your disabled family member as part of your estate planning can be a really great idea because it's going to preserve their eligibility for their benefits. On the other hand, if they're already getting public benefits and they might be in a car accident, get some money because their leg was broken, again, that money is going to take them off of their public benefits. It'd be over $2,000. An individual can have their own special needs trust, but the law says, okay, we won't consider that. We'll let you put that money away into a special needs trust, but it has to have a payback provision that says someday when that trust terminates, Medi-Cal is entitled to get notice and to get paid back if there's anything left. A special needs trust usually terminates either when you run out of money or the beneficiary dies. If it terminates because you run out of money, then there's no payback. So if somebody gets a small personal injury settlement, $30,000, $50,000, they could establish a special needs trust. It goes into the trust. They can use that up during their lifetime, and there's no payback. On the other hand, sometimes there's like a child that's injured at birth, and it's a very large settlement, and that's intended to last their lifetime. And then if they do, when they do pass away, Medi-Cal does get notice. It still is an interest-free loan for the lifetime of that individual that may or may not ever get paid back. So it can still be a benefit. A self-settled or payback trust has to be for somebody who's under the age of 65. It has to be for the sole benefit of that beneficiary, and it does have a payback requirement. So just to differentiate between the third party and the first party, third party, anybody can create that except the beneficiary, their agent, or their spouse. A self-settled can be created by, this is a little crazy because this is the way the law is written. Self-settled has to be created by a parent, a grandparent, a legal guardian, or the court. So when I get a call from another attorney saying, my client just got some money in a personal injury settlement, they want to set up a special needs trust, and so one of the first things I'll say is, how old is he? If he's over 65, then he can't have an individual trust. Next question, does he have a parent or grandparent who's living? Not a brother, not a sister. That is just the way that they wrote the law. It has to be a parent or a grandparent. Although an individual can create their own pooled special needs trust. So pooled is not a different kind because there are first party and third party pooled trusts. but the rules are just a little bit different, and people who are over 65 and a person who doesn't have a parent or a grandparent but is competent can create their own special needs trust. So if you have somebody who maybe wants to qualify for Medi-Cal, they know that their health is declining, they don't have a lot of money, they can take that money, put it into a special needs trust for themselves in a pooled special needs trust. We have one in San Diego that is called the Special Needs Trust Foundation, and I gave you their phone number and their website. This is also a good alternative for the third-party side where there's no payback. If you want an organization to manage the money for your disabled child, and maybe you don't have another family member who's available to act as a successor trustee, you can name the Special Needs Trust Foundation, set up a third-party special needs trust with them for $500. Then in your will or your trust, you can leave funds for that disabled child to the Special Needs Trust Foundation. They will administer it for the life of that child. There's no administration fee, but half of what's left stays with the foundation. And the other half, if you set that up, you can designate who the remainder beneficiaries are. So we usually call a third party, in my office, a supplemental needs trust to differentiate between a special needs trust, which is a first party. It's also the language that Social Security uses. They call them supplemental needs trusts. So you can establish a supplemental needs trust either as part of a living trust, again as a testamentary trust that is set up in your will, or it can be a standalone special needs trust. And I have that highlighted and bold because that's really what I recommend, is to do a standalone. If you think about a trust as a separate, is a box. Trust is a box that you create. You put your property into the box and you control this box while you're alive. Sometimes when people are doing special needs trusts, they'll make the special needs trust a little box inside the bigger box. Well, if you make it a little box inside the bigger box, then other people can't leave property to this little box because it has to go through the bigger box if you want a visualization. If you make it a separate document so that this is your living trust and then this is the separate special needs trust, there's several advantages. I'll go back to that. The advantages are that it can be named as a beneficiary and be funded while the parents are still alive. So when we draft it, the parents are the creators, the settlers, and they're also the trustees. If grandparents want to name that special needs trust, then it's funded while you are living and you could administer that. They may not want to leave money to your special needs trust, to your revocable living trust. They might not want to name that, but they will name something for the grandchild, or they might want to make a special bequest. So it can be funded while you're alive. We have a letter that we give to you to give to all other family members. They can heed the advice in the letter or not, but it tells them that you've created this third-party special needs trust, and that they can name that in any of their own documents and how to name it. It also allows for more information about how to manage it. You might want to have a different trustee for the special needs trust than you have for the revocable living trust. The assets in it could come from several different people, several different grandparents, and they could have different remainder beneficiaries. It also allows for greater privacy because if it's a sub-trust inside your revocable living trust, then any time that the trustee in the future for the special needs trust needs to open up a bank account, they're going to have to copy that whole document just for the few pages of the special needs trust. Sometimes there's contradictory information between what happens with the revocable living trust and what happens with the special needs trust. So it's also it's a little more green if it's a separate piece of paper, a separate trust. Assets can actually be titled in the name of the special needs trust. If you're leaving a house to a disabled child, it would not stay in the name of your revocable trust. It would be retitled in the name of the special needs trust. I've had beneficiaries who have had as many as 4 different special needs trusts set up by divorced parents and grandparents, and it was really quite difficult because you have a little battle, a little turf war between all the trustees about who was going to pay for what. So it's really terrific if you can get the family to all pay into one special needs trust. It's much easier for the beneficiary to have one trustee to deal with rather than 4. So the supplemental needs trusts are usually irrevocable. They need to be because of certain requirements when you're naming the special needs trust as a beneficiary under pension plans. Just because they're irrevocable doesn't mean that you can't amend them. We usually include some amendment rights, like being able to change the successor trustees, being able to change remainder beneficiaries. We usually make some allowance for the trustee to be able to change language in the trust if the laws change. So irrevocable doesn't mean not amendable. They're designed to provide goods and services that are going to supplement that person's quality of life. And I wanted to also point out, many people think that special needs trusts are very restrictive. They are not. Special needs trusts can pay for just about anything, and they frequently do. So people will say, well, you can't use them for food and shelter. Yes, you can use them for food and shelter. If a beneficiary, in fact, if a beneficiary isn't at the moment qualified for public benefits, but you think they might in the future, I'd still recommend a special needs trust because they're usually written with sufficient freedom for the trustee to actually use it as a support trust if necessary, but to kind of flip a switch and turn it into a special needs trust if it needs to be. It can pay for food and shelter. The beneficiary would have to take a little bit less in SSI, but having a special needs trust pay your rent would be an advantage to that would outweigh having to reduce the SSI a little bit. If you have a standalone special needs trust, it can be named by parents and grandparents. It can be named as the beneficiary of life insurance and pension plans, whereas it really shouldn't be if it's a sub-trust inside your trust. It shouldn't be named as a beneficiary. I don't know if any of you have crummy trusts or you have crummy provisions in your current trust, but crummy doesn't mean that it's yucky or not good. Crummy is named after the person who developed it, who passed this law, and it allows parents to make a gift to the children, which they usually refuse, and then it's used to fund life insurance trusts. If they are getting public benefits, they should not be named as a crummy beneficiary because that ability to get the gift, even if it's refused, which it usually is, can interfere with the public benefits. If separated or divorced parents can agree on one trust, like I said, it really is a benefit for that beneficiary. It does depend on the mutual cooperation of the parents. I usually submit my trust to the other parent's estate planning attorney We tweak it so that everybody's happy with the trustees. Sometimes we use a professional fiduciary because that's a neutral party. It isn't the wife's sister, the husband's brother. You've got a neutral person that's administering the trust, so it's easy to get the parents to agree on a neutral person. Can also be the recipient of child support payments, which is a benefit if they're getting SSI. So special needs trust can also be named as a beneficiary for a charitable remainder trust. We talked about life insurance. Okay, who can be a special needs trust trustee? The beneficiary should never be named as their own trustee because that would basically make it not a special needs trust. A capable and reliable family member, and as I mentioned before, somebody who doesn't have financial problems, somebody who has a lot of attention to detail. They're pretty good at balancing their checkbook, keeping their finances in check. A professional fiduciary is also a good choice, especially with a child that's got mental illness. You need to think twice before you name a sibling as the trustee for the child who has mental illness, because having a brother or sister in charge of the finances for their brother or sister never improves a family relationship. It really can do a lot of damage. It would be much better to have a professional fiduciary. Yes, they get paid for that job, but then the sister or brother can just be supportive of that disabled family member, and they don't have to be the bad guy to say no. They don't have to get the calls about, I need the money, I need it right away. A professional fiduciary can do that. Sometimes people like to use a bank or financial services organization. There are also nonprofits. And I gave you the website for PFAC, which is the Professional Fiduciary Association of California. These are all individuals who are licensed by the state. They go through some pretty rigorous training to be licensed. There's a list of people in San Diego, and if that's something that you're interested in, they're all very cooperative about being interviewed if you think that this is something you'd like to do. I often don't name a particular fiduciary though, because you don't know who's going to be taking new clients, who's going to still be in business. I use a trust advisory committee, and I say that trust advisory committee would select a professional fiduciary at the time. If you've met somebody that you really like, you can express a preference for a certain person. The trust advisory committee is the way that I give family members input as to how the trust is used without making them responsible for the day-to-day bill paying, investments, and the phone calls from the beneficiary. So a trust advisory committee can be available to select that trustee, to replace the trustee if the trustee doesn't want to serve anymore, to advise about how money should be spent from that, and to make the family feel like they do still have input. Along with qualifying for Social Security, if you become a conservator for a disabled individual, you're probably also going to become a representative payee, which is another hat that a parent might wear. A representative payee is somebody who gets the check, Social Security check, whether it's SSDI or SSI, for that individual. If you are the conservator, then it's pretty much a given that Social Security will appoint you as the representative payee. You have the responsibility of filing an annual report. If there isn't really anybody to do that, or it's not good for family relationships again, it's sort of like putting a sibling in charge of another sibling's money. If that's not a good plan, there are agencies that will serve in the representative payee capacity as well. So you, as the parents, are going to play many roles. You're going to be, you might be the trustee, you might be the guardian or the conservator, you might be the representative payee, and you might be the friend or companion. And each of those hats has different responsibilities. So you need to think about what those responsibilities are depending on which hat you are wearing. What can families do to educate their successors? Doing the estate plan and doing a memo of intent and trying to figure out, who would step in to take over these roles that I've been fulfilling, even if, not necessarily at the time of your passing, it could be at the time of your incapacity that you're going to need somebody to step in and do that. And that's usually the biggest worry, and it's the biggest load off of parents' mind to know that they've put this down in their documents, they've written their memo of intent, and they can cross that off their list. Where you keep your documents is important. You need to let your family members know where you keep your documents. And that's pretty much the end of my presentation. I know all of this was not in depth, but thank you for coming. Do you have any questions? Yes, in the back.
The question that comes to me that you've been talking about a lot at the end is the trustee, the person who is actually going to make a lot of decisions, and sometimes decisions that may not be so obvious.
Yes.
And so I wonder if you could just comment a little bit on that. For example, if you have one of these separate trusts, and you mentioned the possible trustees, we know that typically financial institutions will do things just by rote. There's a certain amount of income, here's the check. You talked about professional fiduciaries and discussing intentions and all that. Is there enforceability? In other words, if you write intentions and there's a fiduciary over here, can those intentions actually be enforceable, and who would enforce them?
Well, so in an example, like if you're using a professional fiduciary, one way, intentions are not necessarily enforceable. They're informative and they're for guidance. But if you are using a professional fiduciary, then I would probably recommend using a trust advisory committee that you might put other family members on, or trusted advisors, and that professional fiduciary would present them with an accounting on a regular basis of what was being done with the funds, so that you have somebody looking over their shoulder.
How does that work on a practical basis? In other words, this child has a car that is old and is breaking down. How do you know that, as a practical level, is it that trustee that's saying, well, okay, I think it's in bad enough shape that you get a new car? How does that actually play out?
Well, I mean, if the child is able to make requests on their own, then they'd say, my car's broken down and I need a new one, and they'd say that to the trustee, and the trustee would say, either we don't have enough money to buy you a new car, or we do, and what is it that you're interested in? Let's be practical, we're not going to buy you a Corvette. And then they would issue the check.
If
They would
the
not.
child is healthy enough to be able to.
Well, so, that's probably one of those things that would go in the memo of intent, is that, my child isn't going to ask for help. They need somebody to go and visit them on a regular basis to find out what their needs are. Because, I mean, that is the case. Many of them won't ask for help. They need somebody. And that's why I think that my favorite trustee is a professional fiduciary, because they're going to develop the personal relationship with that individual so that they'll call. A bank trust department is solid. They're going to be there, but you're right, it's by rote, and they're going to change trust officers, and they're not going to have the same person to deal with all the time. And for somebody with mental illness, that constant change can be very upsetting. So I know a professional fiduciary is they're going to make an effort to stay in touch with that individual.
Thank you.
Yes.
I have two questions. One of them is, how do you determine if a child is disabled enough to require the special needs trust? Who does it and how? And should I tell you the other one now?
Well, if they really are not able to work or can only work part-time, and they're not able to get health care, or they're a client of regional center, I mean, those are all things that you talk to your attorney about. You know, what are the circumstances, and to make a recommendation. I mean, there are sort of backup plans. In some of my special needs trusts, I'll put criteria for terminating that special needs trust if, in the future, the child is self-supporting and has medical insurance and really doesn't need this trust. The trustee would have discretion to terminate it.
But if the child's under the age of working and you're trying to plan for the future, let's say if you would want to have this set up when they're 18 or 16, so they can declare their, I forget what it is, to declare independence kind of thing. How, you don't know if they can work at that point.
Right. Well, one choice is to just put a clause in your trust that gives your successor trustee the ability to set up a special needs trust in the future if a beneficiary needs to maintain their eligibility for SSI. So the trustee could do it in the future. You can give that right in your trust.
Can you do it before they're 18?
You don't have to.
But no, I'm saying, how, if your kid's not involved in the regional center and is too young to be working, how would you set up the trust? How would you determine if they needed the trust, if they're disabled enough to need it before they're of working age? Or do you have to wait till they're working age?
No, well, so, I mean, I talked to the parents about the diagnosis, what they thought, what they predicted, what they thought. If they thought that there was a good possibility that the child would be able to be self-supporting at some point in the future, then I would probably just put a clause in the trust that would allow for the creation at some point in the future if necessary. If it seemed like the child was a little bit more disabled, I mean, I don't think he's going to be able to work, but I'm not sure. We'd probably go ahead and set it up, have the trust created, choose the trustee, the terms of the trust, but allow the trustee to terminate it in the future if the circumstances change.
And when you say allowed to terminate, I thought that's what I didn't understand about it being irrevocable.
Well, irrevocable means that you can't just say, I undo the trust, but you can give the trustee the power to terminate it under certain circumstances.
Oh, okay.
Then what happens with the money from the trust?
You distribute it to the beneficiary.
Oh, correct,
I mean, if they're working, they have health insurance, they have demonstrated an ability to handle money, I mean, there are several criteria in the trust, then the trustee can terminate the trust and distribute the funds.
I have several questions regarding the SSDI. If the child was over 18, has the SSDI, does that inhibit their ability to work at all?
Yes, they can't earn over $1,000 a month and still get SSDI.
They can earn less than $1,000 a month doing
Yeah.
SSDI?
So you have to be really,
And you all, I mean, if they get SSDI, there are also issues about marriage because if you get SSDI, there's a deeming between spouses. So you want to get them qualified prior to marriage as opposed, because once they're married, there's spouse to spouse deeming. So
So that means that the spouse's income is taken into consideration.
yeah.
His family income. What
Yes.
about if they're not married, if they're over 18 or over 21? And does that mean that the parent then, if the parent can no longer take them as a dependent off their taxes, for example, for other medical things that are not covered? Or, for example, if a parent, if the medical expenses that a parent pays are over 7.5% of the parent's income, and the child say is under 26, that is, if the child has SSDI, independently, can the parent still, on their income taxes, claim the expenses that the parents pay?
Well, I think that depends on how much you're contributing to their care. I mean, there's certain definitions in the code as to whether or not they would qualify. But I think it's going to be tough once they're getting SSDI because that for the most part is going to take care of their food, their shelter.
And so the parent's income then is no longer, when they're getting SSDI,
The parents'
income is not taken into
parents'
consideration.
income only counts up until they're 18, and if they're a client of regional center, there's a waiver program so that the parents' income and resources don't count anyway. So, but at 18, then they start to qualify on their own. So that's how, a child whose parents have quite a bit of income, they can't qualify, then they can qualify under their own resources and income at 18.
And my last question on that regarding the SSDI is then, at the point of the parent dies and the child inherits, do they lose the SSDI at the point that they inherit?
No.
If it's not in a special needs trust, but it's SSD, they're getting SSDI.
Right, well, yeah, the SSDI would not go into the special needs trust. So, no, when the parent dies, it actually goes up.
So when the parent dies, they would get their normal inheritance, even if it's not in the special needs trust, they would get the normal inheritance and continue their SSDI?
Yes, but not the SSI.
Right.
Yeah.
I understand.
I wonder so what I heard you asking, I wonder if you heard it the same way I did, but are you asking if what happens to the inheritance or how the inheritance affects the child?
I'm wondering if the inheritance affects the child's ability to get the SSDI.
Right.
No. Yes?
I have my second question.
Oh, okay.
Is there any downside, long-term, for the child of having a special needs trust once you set that up?
Not really. I mean, the child may not be happy about it because they don't have access to what they would think of as their inheritance. My brother and my sister, they get their money outright. Mine's in a special needs trust.
Any other stigma kind of thing that would prevent them from succeeding if they improve somehow?
Well, yes, I mean, we could certainly put that in the trust that it could be terminated. So, I mean, the negative might just be that it's going to make that child unhappy. Otherwise, I mean, there really isn't a downside because of the flexibility that's usually built into the trust. So, I mean, if you're not sure, it would be better to err on the side of using the special needs trust as opposed to not.
Yeah, I'm talking about maybe some social reasons that might impede them if they are, suddenly we've got some cure for bipolar or something like that, and the kid's doing fine, and then someone's looking into their records that you had special needs trust, and is that going to reflect badly on them or something like that, to impede their success?
I wouldn't think so. I don't. Yes.
There are standard forms for a lot of legal things like leases and mortgages even and so forth. I gather that in the case of these trusts, there is no such standard thing. Each one is individually crafted.
Yes, there's certainly somewhat standard parts of it, language that must be included, but they are individualized. Yeah, don't go to LegalZoom and do these. I mean, you know, I've seen the documents, and people have inadvertently disinherited their children with using something like that. It's not worth the savings. So, and even like the powers of attorney, you can get those from like stationery stores or you know, a form online, but they're very basic, and they don't give you some of the special powers that you might need in certain circumstances. So that's why you really need to go to an attorney and tell them what you need. Certain things have to be specifically spelled out, like if an agent can engage in acts that are self-dealing or benefit themselves, that has to be spelled out in the document. Otherwise, you can't do it. It has to be specifically spelled out that somebody can create a trust, or else the power of attorney doesn't allow you to do that. So those are just a couple of things that, you know, you would get from an attorney drafting the special needs trust as opposed to printing off a form. Yes?
Yeah, I just, yeah, the revocable and irrevocable trust, why would you want to set up an irrevocable trust, something that you couldn't change?
For your estate planning, like, you know, when you're just doing your own estate planning, I wouldn't recommend an irrevocable trust. But for some pension plans and 401ks, in order to name a trust, it has to be an irrevocable trust. So not for your own estate planning that you would maybe transfer title to your real property, that kind of thing. But the third party special needs trust, if it's going to be the beneficiary for like an IRA, the regulations state that it has to be an irrevocable trust.
Can a trustee live in another state?
Yeah. Yeah, I mean, they don't have to be right there. I mean, there are ways to, you know, hire somebody to go to visit the beneficiary and advise the trustee. I mean, it might be a hurdle, but there's nothing illegal or wrong with having somebody in another state. Yes?
Just following on this to make sure I understand, it's really a tax question. What if you are providing, not SSI or SSDI, but you are providing for a child who essentially is disabled, but an adult? There's no tax deduction, is there for that?
They're not getting any income on their own?
No income on their own. They are essentially disabled. But,
Well, yeah, I mean, yes.
but not already receiving SSI. That you're aware of. I mean,
They could potentially be a dependent, but there's a
there is a definition in the code.
Yes.
And the only other comment I'd like to make, and it was asked here, I think one of the most challenging things is, you know, when you say, well, what if a child suddenly gets better? It's really tough when you're trying to figure out who could be a good trustee when can be nuanced, you know, as to how you respond. I'm sure you get a lot of that.
Yeah, I mean, that can sometimes be the sort of sticking point to actually getting the estate plan done.
Yeah.
Is either figuring out who's going to be the successor trustee, or, you know, who's going to be in charge of our minor children or our adult disabled children, and the parents can't agree. And But, I mean, it's better to just come to some decision and pick it, because you can always change. If you don't do it, the court's gonna do it for you. And that may not, you know, they don't know your family like you do.
If you appoint a fiduciary person, and you said that if they don't get an administrative fee, but when, say, the child would pass away, they get half of what's left.
The pooled trust.
The pool trust, correct, and the pool trust. Then, I guess, why would there be any incentive in them to spend any money on the child requests it? I mean, the more that's left behind, the more they're gonna get. I mean, is there a system of checks? I mean, that's a Sicilian who's coming out. I mean, I'm sorry, but does it go? You know, they're gonna be subsistence living.
Because a trustee has a fiduciary duty to use the money for that, for the benefit of that individual.
Right, but you were dealing with mental health, you know, children or adults who are not going to be able to necessarily fight for themselves. You know, it's kind of, I think is there a system of checks and balances in that?
In
to make sure that they get more than just a, you know, because let's say my child isn't going to go and complain, they won't even know where to go.
Right.
So as part of the process of joining, if you use the Special Needs Trust Foundation, you name advocates for your children within the documents. So those are individuals that can make requests on behalf of the beneficiary for, you know, the car, the clothing, whatever they need. So it isn't just the beneficiary and the trustee. You have some family members or friends or whoever that are going to speak up for that person.
So it's important to have those advocates, obviously.
Yes, absolutely. Yes.
So if you want to set something like this up, would you go to somebody like you or somebody, or what kind of lawyer are you looking for? Do they have to specify that they do special needs trusts, and how do they qualify to do that? How do you know that they're qualified to do that?
I would probably talk to people who've already set up a special needs trust. I mean, there are a couple of websites. If you picked up any of those brochures, on the back, there's a website called the Special Needs Alliance. And the Special Needs Alliance is a national organization of special needs trust attorneys, and you can look at that list. But I'm the only one in San Diego. You're invited to become a member of the organization. But there are other organizations that have special needs trust attorneys. There's another organization called Special Needs Planners that have a couple of attorneys from San Diego. Otherwise, I think that recommendations from people that have already done them.
So is there a special requirement or education or certification?
No, there isn't. That's why you know, you probably need to ask around. I would go to the attorney and ask them some questions about special needs trusts. I mean, you could ask them now, tell me, what's the difference between a first party and a third party special needs trust? If they can't answer that question, you don't want to use that. Yes, Susan? We have a professional fiduciary here.
I'm Susan Fox, and I'm the group administrator for the San Diego Special Needs Trust Administration Study Group, which Carol and I founded in 2004. And we meet monthly, and so I've been familiar with many special needs trusts and the many special needs trust attorneys or attorneys who say that they can create a special needs trust. And I just want to emphasize that, in my opinion, Carol is the leading attorney in San Diego, in the state, basically, for creating these kinds of documents. And some attorneys will say that they know how to create a special needs trust, and they really do not. It's important that you get an attorney who is interested in the fact that you have a special needs child, that isn't the document that they're creating that's important to them, and if they are truly interested in your welfare, if they don't know how to do it, they're going to recommend Carol, or they're going to recommend a person who is qualified. Because as a trustee, trustee, once I receive that document, if it's not crafted well, it's very difficult to administer.
And
It's expensive.
and sometimes you
it's
have to go to
stressful.
court, and that's expensive.
And it's stressful for everyone, so I'm just giving my personal testimony.
Thank you, Susan, and she wasn't paid to come.
I wasn't, but I came here because I always want to learn. Whenever Carol gives a lecture, I try to attend them because I think that I learn a lot too, right along with the audience. So
Thank you.
The foundation.
I'm not with the Sandy Special Needs Trust Foundation. I'm one of those people that's in the PFAC, the Professional Fiduciary Association of California.
Yeah, there's a state plan.
I think that you need to go to someone that says Special Needs Trust. As you know, Carol's the only one with Special Needs Alliance in San Diego. It's a very special skill.
But there are some questions that, maybe you can take from some of the information here that, if you can ask an attorney, and if they can't answer some of those questions about, like, the difference between the two kinds of special needs trusts, then they really don't know. I do get a fair amount of business just fixing what other attorneys have done, and I look at it and, either the parents have already passed away, we have to go to court to fix it, or, sometimes I'm lucky I get it and we can still fix it while they're still alive. So it is important to make sure that you do have somebody that does know what they're doing, because if not, it can be a bigger mess than if you had done nothing.
And the thing is, it's very upsetting to the beneficiary.
Yeah.
Not only a trustee, or the fact that the trustee isn't able to carry out the parents' wishes as they thought, but the beneficiary is a disabled person. And to have this controversy swirling around and perhaps not being able to make the distributions until it's settled is very upsetting to them, and it can exacerbate their whatever their illness is.
Right.
Makes it worse.
Yeah, it adds to their stress. It definitely does.
What was your name?
I'm Susan Fox, but there are many qualified fiduciaries in San Diego.
Well, thank you.